Welcome to Capsule 5 of the International Mediation Symposium. The symposium is brought to you by the International Academy of Mediators and the Hong Kong Mediation Council. So, ladies and gentlemen, I extend a very warm welcome to you and to our speakers. Before I introduce them, I would like to acknowledge the contribution of our sponsors, without whose generosity this capsule and the symposium would not have been possible. Now, on the screen in front of you, you will see the names of all our sponsors. So welcome once again to this capsule. In this capsule, we'll be looking at some of the issues relating to mediation advocacy. So in particular, how a mediation advocate can effectively promote the interests of his client and to promote the chances of a settlement in different phases of the process. Now, the title of today's talk is Manipulative Advocates, How to Respond. Well, we chose the word manipulative advisedly because we want to stimulate a bit of discussion, because as you know, manipulation can be good as well as bad. So we chose this title in order to be provocative. But rest assured that we will cover every aspect of the manipulation. Now, I would like to first of all talk about the pre-mediation process. But before that, I would like to introduce my co-speakers. Today, we have the great honor and privilege to have on board Professor Dwight Golan. Now, Professor Golan is a faculty member of Sussex University in Massachusetts. He is the author of very important books on commercial mediation and mediation advocacy. Professor Golan was formerly a litigator in private practice, and he served as the chief litigator for the state of Massachusetts. Today, Professor Golan is the scholar in residence of the IAM. Now, turning to my next co-speaker, Michel Kalapetis, QC. He requires very little introduction. He is one of UK's leading mediators. Had 40 years as in the field of commercial, professional diligence, and employment work. He is a member of Independent Mediators Limited, where he practices full-time as a mediator. Michel is a distinguished fellow and vice president of the IAM, and indeed the president-elect of IAM. So welcome, Michel. Last but not least, we have Ms. Jodie Sin, who is the current vice chairperson of Hong Kong Mediation Council. Jodie practices as a solicitor in Hong Kong and has a wide experience in commercial litigation before becoming a full-time mediation practitioner. So welcome to you all. Now, as I said, we are going to go through this talk by discussing various stages of mediation and the use of advocacy in each stage. So to kick off the discussion, I would like to tell you a story. So just give me a second while I put up the slides. And now I will try to share the screen with you. So in the pre-mediation stage, very often we have the issue of trying to decide who are the right people to attend mediation. And this story, which comes from a real case in the UK, is a very useful lesson. So this is a case of the Solicitors Regulation Authority versus Benjamin. Now, Benjamin is a solicitor in the UK. Before a mediation session began, he lied to the other side's solicitor about his intention to instruct counsel to attend the mediation. And on the day of the mediation itself, Benjamin lied again. And this time he said to the other side and also to the mediator that his counsel had to withdraw at the last minute due to a family emergency. Now, when this lie was subsequently exposed, the Solicitors Regulation Authority prosecuted Benjamin for professional misconduct. And the result of the proceedings was that he got struck off the roll of solicitors. And that goes to show how seriously his misconduct was considered to be. Now, what's interesting for our present purposes is the statement that he made in mitigation. And he told the tribunal this. By stating counsel would attend the mediation, there was a feigned perception of strength in my former client's position and defense to the threatened claim. So in other words, he was hoping that by bringing along counsel, he would be able to be seen in a more favorable light on the merits of his client's case. And in this case, his client was the proposed defendant to a claim. Now, I also want to tell you what the other side said in response to that statement. So the other side's solicitor made this statement in the proceedings. He said, my firm and my client would not have proceeded with the mediation had we been told beforehand that counsel would not be attending on behalf of the defendant. So from his point of view, he was very disappointed and angry because he was hoping to see counsel for the other side turning up and telling him what the proposed merits of the defense might be. Now, whether or not this gentleman genuinely thought that is a different matter, but the story tells us perhaps a little bit about the mentality of a lot of lawyers who are engaged in mediation. They either think that mediation is litigation by extension or a precursor to the real fight. Now, in this particular case, the solicitor for the plaintiff was hoping to find out what the defense was going to be. And he proposed to do that by going to the mediation and listening to the barrister who he believed was going to attend. But is that a proper purpose of mediation? In this case, the solicitor in question clearly abused his ethical duty because he told a blatant lie, not only to the mediator, but also to the other side. But in other cases, there are other forms of manipulation which are perhaps less blatant and more subtle. Now, coming back to the question of who should attend the pre-mediation, the mediation process, one of the most important things for a mediation advocate and also for the mediator to think about before the mediation is who are the right people who should attend. For example, if I have a client who is a company, they might not send the appropriate person with the correct authority to come to the negotiation table. And that could cause a problem. And as a mediation advocate, I could sometimes use the mediator to persuade my client to send somebody who is higher up in the hierarchy to attend the mediation in order to make sure that the negotiation would not be a complete waste of time. Okay. And by the same token, I can also use the mediator to persuade the other side to send somebody from their company who has a correspondent authority or their right amount of authority at least to the negotiation table. So that's one of the important things I think that a mediation advocate should ensure and should do before a mediation starts. So with those introductory words, I would like to hand over to my co-speaker, Professor Golan. So, Professor.
Well, CW, thank you very much. Thank you, Michelle and Jody. Let me share my screen and let me talk a little bit about what I've seen developing in the United States over the past 20 years. There really hasn't been manipulation in the sense of an unethical practice. It's been more manipulation in the way lawyers try to bend the process and present trials and make decisions go in their direction or their client's direction. We find that US lawyers now use mediation voluntarily. I'm sure there are at least 1 million mediations a year in the United States. But you ask, well, why would they? Particularly, why would they pay thousands of US dollars and spend days, locked in, not locked quite, in rooms? And here are some reasons. I see lawyers using mediations first to create a settlement event. This was more true before COVID, I must admit, but when you had to spend large amounts of time and money to bring yourself, your client, the other side and their client all to the same place, it's a mutual signal between the two sides. We're serious about talking settlement. And of course, it's harder to leave if you're frustrated, upset, etc. Also, of course, and as CW's indicated, they do it to get access, direct access to the opposing decision maker, because in US litigation practice, you never talk to the decision maker on the other side. The best you can do perhaps is call them as a witness and cross-examine them, but that isn't very satisfactory. Mediation, of course, is a completely different framework. I find lawyers, I'll talk about this and show you examples in video, they use us as boxing gloves to cushion the impact of hard bargaining strategies that would drive the other side away, but keep them there because the mediator is working to do it. Clients get emotional. That's of course true in some kinds of cases. It's also true in business cases, the kind I handle, except they won't admit that they're emotional sometimes. And the lawyers really can't deal with it consistent with their role as loyal warriors. So they have the mediator deal with it. I become a kind of informal therapist sometimes. Sometimes they want a mediator to deliver bad news, unwelcome opinions to opponents, but also to their own clients who they're having difficulty understand the need for compromise. And they use our credibility to support their proposals and options and solutions. So if I had general advice, it would be, look, do not enter mediation passively as if you're selecting a good surgeon and you're counting on him or her to operate on the correct leg. I think you should be trying to influence the neutral and the process. Yes, manipulate them if you will, but in an ethical sense. And the question is, what can this mediator accomplish for me and my client? How can I use the process and the variations in it to enhance my ability to negotiate? And the first question, as CW indicates, is what's done before the mediation, because more and more in the last decade and a half, US lawyers do a great deal before the mediation to set up the chessboard so that they are in a good position to begin the game, I'll say. So specifically, get the key player present. They get me signed up. They get me to think of it as my mediation that needs to be successful. And then they tell me the first thing I need to do is to get some reluctant person on the other side to attend. And of course, I'm psychologically and professionally interested in doing that. Sometimes they need information. A lawyer for the defense needs information to persuade his insurer to provide enough money to settle the case. A lawyer for the plaintiff may not understand the defenses or need key expert information. Again, they're more willing to do it in the context of mediation. You can influence the format of the process. We won't have much time today to talk about format, but you can influence it, I think, in important ways. Now, to show you a bit, I think what I'd like to do is to give you a case. It's an actual case involving a Hong Kong businessman who made a relationship with a small American software company to distribute their software in the PRC. And he would get a commission on the sales and as well as a commission on sales they made through other agents. And the process went along very well for several years. Then the US company encountered a cash flow crisis. And the Hong Kong businessman advanced them almost $2 million US. There was no loan document. There was simply an agreement that he would get an enhanced commission for a period of years until the $2 million was repaid. But they never changed the contract because contracts, I guess, are not as important in that context. This was fine for about 3 years until a major US company acquired the small US company and took the attitude that they did not see any evidence that there was a loan. They did not see any contract requiring enhanced commissions, and they simply cut off the Hong Kong businessman who sued. I have filmed a mediation of this case, and I can't show you the entire 12 hours of mediation or even the hour and a half of the video, but I'm going to show you 2-minute segments, and I'll ask you to fill in everything you can't see because it allows us to see a little bit of what happens in the pre-mediation setting and then later. So here is the video. Let me make sure, and if there's any problem, I'm sure CW will tell me.
What I would like to ask both of you to do is to give me mediation statement.
Will we be sending these statements to you or to you and the other side? My suggestion would be, we're bringing people a great distance and we want them to make decisions, that briefs be exchanged and then maybe a separate 1 or 2 page letter be sent privately discussing settlement ideas or barriers, which would be a confidential communication.
That is certainly acceptable to me.
Now, after the conference call, the mediator, and this is Michael Lewis, who taught at Harvard for more than 20 years, one of our leading mediators, he had private conversations with each lawyer, and I'm going to show you just 20 seconds of each one.
Anything else?
Well, I know he feels, Mr. Kim had a great relationship with Mr. Lyons and had been doing business for 10 years. He doesn't know the folks at Green Consulting very well. And so my sense is he feels like he just has not been treated very well.
Okay.
So the mediators learned about a potential emotional issue, which might never be mentioned in business conversations, but it's there. So now the defense lawyer.
Do you have any questions about the mediation?
Well, let me just say, we're looking for you to have a strong role here because they need to understand, what the law is, how transactions are done, and there seems to be a gap or lack of understanding there. And we hope that you'll play a role in, moving that forward.
CW, Michelle, and Jody can say what that would mean if it were said to them. I know it's said in the United States, it means we want you to give an evaluation to tell the other side they have a big legal problem. So now let's see what the mediator does.
Well, my goal is to get you to an agreement. So I will do everything I can to get there. So we'll see how it pans out.
Well, that's why we picked you.
Okay.
So as a little barb at the end, that's why we picked you, just reminding him that he depends on being picked by both sides who are paying him, and they expect performance. With that, I'll turn it back to the panel.
Thank you, Dwight. Now, Jody, have you ever had such experience of being asked to give an explicit evaluation to the other side?
Not really. I think in Hong Kong, we seldom or we rarely do evaluative mediation, and it's only sometimes at the late stage of the process that some parties will request the mediator to talk to their clients about the merits of the case. But I did not do evaluation. I would just ask some questions about the case, like what evidence do you have on this or that? let me hear your arguments about this. And they say something at the joint session. How would you deal with that argument? So this is something that I would usually do.
I see. I think we'll come back to the topic of evaluative skills at the end of this webinar. I think a lot of us in Hong Kong are very interested in this topic because it's something that a lot of people are afraid of doing for various reasons. But perhaps we can move from the pre-mediation stage now to the opening joint session, which is something that I think Michelle is very much in favor of having. And but here, I think in some of the mediations I've had in Hong Kong, some of the parties would very strongly resist the idea of bringing the parties together in the same room at the start. I think part of the reason is the fear of confrontation, especially in cases where relationship has broken down. But to my mind, it might, and in most cases, it is the best opportunity for the parties to build or rebuild a rapport, to establish or re-establish communication, and to exchange information, whether by gathering or by conveying information to the other side. And to my mind, also having an opening joint session is important because a lot of litigants look forward to the day in court. And the mediation can be a proxy of that, but be better because it allows the parties to express the needs, the concerns, their interests in a way that no court proceedings or no paper evidence can convey to the other side. Of course, it also allows parties to vent their emotions so that they can get that out of the way and get down to the business of negotiation. Do you agree, Dwight?
I must tell you that the joint session is an endangered species in the United States. It has disappeared on the West Coast, and it is like a blight that is heading to the east. Here in my eastern part of the United States, we still use it. I find it useful. I've gotten used to thinking about what I'm going to do if they won't meet jointly. However, I would argue, and let me suggest some things that maybe counsel can do and see a little bit more of our video. But let me just a motion or two. It seems to me that when it's done well, yes, it's a unique opportunity from my perspective for a lawyer to speak directly to the opposing decision maker. It's the only chance, as I say. I think it raises tactical questions. Should it be the lawyer who speaks? Should the client speak? And if so, what should each talk about? There's always a balance about the tone. Do you hold out the olive branch of peace? Do you wield the sword of war? Do you show a little bit of both, and in what order? I think those are tactical issues which good lawyers think about because in my mediations, both are present, I should say. And are you going to focus on legal issues? Are you going to focus on business, personal matters? Or are you, again, going to try to sort of do both? Again, returning to our video, let me show you just little bits and watch what happens. The first thing you'll notice, I will say, is having seen Jody mediate, where she had the clients next to her, the first thing we see is that, in this case, the lawyers want to be next to the mediator. That's a tactical choice to begin with, but let's see some.
Welcome, everyone. And especially Ms. McLaurin and Mr. Kim.
My client is seeking to be paid money he's owed. You want to say something?
So,
Am I allowed to say something?
yeah, absolutely you are.
So let me just say that I worked very hard to help Monitor penetrate the China market.
Mm-hmm.
Without someone like me, with my extensive network connections, a company like Monitor has zero chance of success. I came to them in their time of need with a cash infusion of a significant amount. I had a close relationship with Mr. Lyons, and then all of a sudden, the rug was pulled out from under me, everything disappeared without the courtesy of a phone call. This company said,
I don't think you're playing. I can't see the video. Can you do it again?
Yeah, so you remind me.
Yes.
Let's see. I've got to, I put the video on.
Sorry about that.
Let me stop the share for a second, do this correctly. It's always a problem between it being on my video, my screen, and your screen, but we'll get it right. Okay. Let's try that again. And I'll move it back just to see him, perhaps.
So let me just say that I worked very hard to help Monitor penetrate the China market. Without someone like me with my extensive network connections, a company like Monitor has zero chance of success. I came to them in their time of need with a cash infusion of a significant amount. I had a close relationship with Mr. Lyons, and then all of a sudden, the rug was pulled out from under me, everything disappeared. Without the courtesy of a phone call, this company said, sorry, it's not our problem, it's yours.
You'll notice that he looked at the mediator. It's his day in court, as CW said. But every so often when he talked about the phone call that wasn't returned, the lack of respect, you'd see his eyes shift briefly over to the executive on the other side. So now the lawyer on the other side has to decide who's going to speak for the defendant.
Thank you. Mr. Smith, Ms. McLaurin.
We think frank communication is the most businesslike way to resolve this dispute. So I would like to address my remarks first at a business level and then to our legal position. We bought the assets of Monitor so we would not acquire their liabilities. And that was the reason we did that. The problem you have that they didn't put your loan on the books, that's as much a surprise to us as it is to you. And so in a business sense, we feel victimized by Monitor. And we understand why you would feel the same way.
So he starts off in a business vein talking directly to this CEO on the other side. So much for the olive branch.
If a court were to agree with us on our counterclaim, we would be entitled to recover our legal fees. Now, is a lawsuit the best way to resolve this? No. The best way is to come here to this mediation and for us to exchange information and have frank discussions.
Ms. McLaurin, do you have anything to add at this point?
Just briefly, it is a pleasure to meet Mr. Kim. Our feeling is that we were all duped by Monitor.
May I respond briefly since Mr. Smith was addressing me directly?
Oh, please.
So you were talking about American business and culture. I've been a businessman for a long time, so I know what an asset sale is.
So there are these feelings going on. And many lawyers aren't entirely comfortable seeing them have that happen in the opening session, but it is, I think, part of the process, at least in the Eastern United States, and I gather also in Southeast Asia, perhaps also in Britain.
I see. Thank you, Professor. So I have encountered, and I think Jody may have had the same experience, of advocates who feel their duty is to protect their clients, and instead of promoting or encouraging communication, the advocate acts in a way that seems to obstruct the flow of conversation or even emotions. Perhaps, Jody, you would like to share with us some stories on your side?
Yes. I call this type of advocates, you speak to me only advocates. So there was a personal injury case that I mediated. The plaintiff was a 60-year-old lady, so she came with her son and her counsel. And the defendants on the other side represented by a solicitor. So 9:30 a.m., so the plaintiff solicitor, let's call him Mr. X, right? So he said to me, Ms. Sin, you do not need to speak to my clients. So today I'm fully authorized to appear in this mediation, and I would do the negotiation. So this is not the first time I saw this. So I tried very hard to engage the old lady. But what has become more problematic is that when we were in a joint session, the defendant solicitors tried to ask some questions about the accident. So Mr. X even stopped the plaintiff or her son from answering the question. So I would think this is well, a lack of understanding of the concepts of mediation, especially what I call the facilitative model. So mediation is a process of the client. So the parties are not there to testify, and I don't understand why the council was so keen to stop the communication. And I think it's definitely a misconception of the role of a mediation advocate. So protecting the client, he thought, all right, controlling the scene, but he's trying to score points. But I'm not too sure whether this really achieved the objectives of his client, like coming to achieve a settlement.
I see. So that's a bad example. So Michelle, do you have similar experience that you might want to share with us?
Yes, indeed. I've had solicitors say to me directly, "I'm not allowing my client to speak, and I will do the speaking in the open session." Well, that is a bit like a red rag to a bull to me, I'm afraid, because the whole purpose of mediation is for the clients to resolve their disputes rather than the lawyers show off how good or bad he is, and usually it's the latter. It seems to me that if there is a difficulty, if the client has a weakness, then it's far better to face up to that in a mediation than wait until you're 3 or 4 days into trial before everybody else realizes it. But I have ways of engaging clients in speaking in spite of their lawyers. And I have this sort of trick. I listen to the lawyers on each side, and when everybody's finished speaking, I turn to the client on one side and say, "Look, can I just understand your case? Have I understood correctly that on this particular day, you saw Joe opposite, and he said this, and on the basis of that, you did what you complain about in terms of the contract? Have I got that right?" Now, if I've asked that question directly of a client, no lawyer is going to intervene and say, "I forbid you to answer the mediator's question." And so once he begins to speak, I then turn to the other side of the client and say, "Well, do you agree with that, or do you have a different version?" And again, engage him. And so this way I've engineered, manipulated, if you like, a discussion between the two clients in spite of their lawyers, which always is productive, even if they are angry with each other and they have to vent, as you referred to earlier, CW, they get it off their chests in that open session. And then it makes it much easier for the mediator to say, "Well, look, that's fine, but how are we going to resolve this? So what do you need out of a settlement?" So the way I think that a mediator responds to a lawyer who's trying to block any question from his client, the mediator, done in an obviously perfectly charming and gentle way, can circumvent that.
Yes, thank you for that great tip. I'll certainly bear it in mind. So once a mediation gets going in a joint session, it may be time for the parties to make the first offers, but very rarely do we see this happen before lunch, I mean, in my experience. But when it does start, it tends to start like this. The advocate on one side would start with an extreme first offer, which is no different in practice from what he is demanding in the statement of claim. And that kicks off usually a process, an agonizing long process of cold positional bargaining, with each side moving an inch at a time. And that process in commercial negotiations can sometimes be a source of frustration, anger, and people walk out where they run out of patience. Now, I don't know if that's the common observation among my co-speakers, but one of the reasons why I think people do that is that they either perceive that as a way of showing the confidence in their own case, or they actually expect the other side to do the same thing. So they would start at the opposite extreme. And there are, of course, a lot of psychological aspects to this, saying things like the anchoring effect, or what's sometimes known as the contrast effect, which is sometimes used as a tactic, psychological tactic, right? I start off high, and later when I go down to the middle, it would look like I made a big concession, and make myself look very reasonable as a negotiator. So what's the solution to this, Professor?
I don't have a solution. I think the sad truth, I must say, is that yes, I call it the dirty little secret, at least in American mediation, but I gather it's not just American. Mediators, people in mediation can use harder strategies than they could manage in a direct negotiation. If they did this at a direct bargaining session or in a phone call, the other side would simply hang up or leave. But in a mediation, you've got several things going on. You've got that investment that everyone's made to go there. You've got the fact that the mediator is there to, I call it, scrape the other side off the ceiling by trying to get them to think about it, to interpret it, to understand it as part of a process, and so on. So the mediator cushions the impact. I said I'm the boxing glove, sometimes I'm the padding of the walls of the room, I guess you would say, so they can bounce off it without doing each other damage. It gives clients and lawyers sometimes emotional satisfaction, that they can be angry, they can be tough, they can tell the other side just what they think. I sometimes think they're saying, I spit on your case. And this is their way of doing it. But also, as you say, there's the contrast effect, there's anchoring and so on. But they're relying on us, the mediator, to prevent an impasse. And I understand it, they know it. Sometimes a lawyer will give a hard public offer to the other side and send a slightly more positive private signal to me saying, you know, we're going to be tough as long as they're tough, but if they ever get, quote, reasonable, unquote, we might be willing to do something. This is the only exception I've ever seen is I recently did a video of a Christian mediator who does Christian mediation, and he was able to cite the golden rule and actually get two business partners to make reasonable offers, but it is very much the exception. Let's see what happens, just to see one example in the Hong Kong US mediation.
So, got a fairly significant move from them.
Notice the mediator's immediately characterizing what he got from the plaintiff, $100,000, as a fairly significant move.
I want to talk to you about, and then need to ask you to think seriously and make a response. They have moved to 1.375, and that is a reduction of $100,000 off of what they actually believe they are due. I need a response from you.
Let us consult. We'll get back to you.
Okay, absolutely.
I know you want to settle this case for $300,000 or less. The thing that I'm concerned about in the bargaining is that we not adopt their analysis or let them think that we've adopted their analysis. My recommendation to you is to make a move, but we should communicate the move to be the cost of our defense, because we view their claims and continue to view their claims as frivolous.
So, where are you?
Well, a couple of thoughts. We value the case at $250,000, the cost of defense. So we would offer a net $250,000 to them. And I'm not going to say that's our last and final offer, but that reflects our view of the value of this situation to us.
So it's only going to cost Green Consulting $250 to try this?
So now we get evaluative. I know he just asked a question, but you all heard the tone and the look he gave, and it's quite clear to any savvy executive that this mediator is saying, I know and you can't possibly defend this case for $250,000. But on we go.
We'll see.
Surprises me. So 250. Well, I will take it back to them. I am not optimistic, and I'm concerned that it may send a signal that will encourage them to leave rather than to stay and continue to negotiate. But if that's where you are, that's where you are.
That's where we are.
All right, well, let me take it to them.
So, the lawyer's been tough. He relies on the mediator to keep the other side in the room. I'm fairly certain that if the mediator weren't there, the other side would be walking out. But in fact, he knows the mediator will keep the other side there, do all the things we do. And so, yes, we spend hours and hours and days and weeks sometimes doing this kind of back and forth bargaining. I have war stories, but I will turn it over to the panel before I offer any.
Yes, thank you, Dwight. So that is perhaps an example of good manipulation, and mediators, as you say, really expect that to be part of their job, right? Perhaps, Jody, you have similar stories to share with us? Jody, you need to, yes.
Yeah, got it. Beginning with a low offer, I think, is something really commonplace. What I had was in a case that I mediated. Again, it's a personal injury case. That was a very interesting one. So the plaintiff's case, the merits was pretty weak. A lot of expert reports were exchanged, but it looks like the experts did not quite support the plaintiff's claim. And so before coming to the mediation, the defendant made a sanctioned payment. So it's something like 500K. And so after the joint session, we started some kind of bargaining. And then I was in the defendant's room, and then I said, what will be your first offer? So there's very natural expectation that sanction payment X dollars, and the natural expectation of the plaintiff will be coming to the mediation, there'll be something plus X, right? And what I got was, Jody, the 500K that we made for the sanction payment is now off the table. So we're going to offer 300K, and we will ask the plaintiff to pay the defendant's costs from the expiry date of the sanction payment up to the date of mediation. So this is something like what I would call a nightmarish first offer. So I sit there and then I said, can you tell me why this happened? And well, if you're going to, because well, under the Hong Kong court rules, I think you can definitely apply to the court for diminution of the sanction payment if you want to. And then I was told, that's my client's instruction. So that was what the defendant solicitors told me. So I think this is really a kind of very big surprise to me, going back from the previous offer. This is something that I always tell my parties if they have any negotiation before coming to the mediation. It's better not to go backwards. It's better than not making any move, but going backwards is definitely unhelpful.
I see. So backpedaling, I mean, I've never seen that happen in real life. I mean, it's...
Yes, yeah.
So Michelle, anything you want to share on this topic of hard bargaining and how people go about?
Well, two things, CW. Your remark that you seldom get an offer before lunch. I use humor a lot, depending upon the nature of the dispute, but in commercial disputes, I say to the insurers particularly, I've got a new rule. No offer, no lunch. And this usually causes a laugh. They get the message. It's difficult to enforce that rule these days because we're doing everything remotely, and I am not in charge of lunch, but in a real person-to-person, I usually am. But no, what I do when somebody's making a very, forgive me, stupid first offer, I do challenge them. What are you hoping to achieve with that? We want to lower the expectations. Well, you've done that. But what do you think the reaction is going to be? And then if they insist on me taking what is obviously a stupid offer to the other side, I then have to manage the other side when I'm presenting that offer. And if I go in and say, look, I've got a great offer for you, it's $250,000 as in the clip. Yeah. Not only do the other side lose credibility, but so do I. And so what I normally do is I make light of it. And I put both hands in my pocket. And I say, you'll notice that before I give you their offer, I got both hands in my pocket. So they get the impression this is going to be a pretty poor offer and they're not going to bite my hand off and take it. And so, again, soften the blow. And I think that's our role. If one side wants to play hard, but you know as a mediator, that's going to have the opposite effect in the other side's room, then soften the blow because that's our job. It's rather like, as Professor said, using us as boxing gloves to soften the blow of a hard and rather stupid offer. And then if one does that and you want a response, my comment usually is, well, look, if they're being silly, there's no reason for you to be silly. You're here to be serious. Give them an offer to make them come back to you with a sensible offer if it's going to get this done. And that usually works. Otherwise, you get this, well, we come down 2%, we're going to go back 2%. And you have this sort of inch-like snail's pace, which drives everybody insane, including the mediator. And so I try and cut through that by getting somebody to make the first move, which I believe is the most important move any side makes in a mediation. It's the first offer is the most important one because it sets the tone for the rest of the mediation.
I see. Thank you, Michelle. So perhaps I would like to have Dwight comment on this. When people get locked into positional bargaining, what can a mediator do to help them think out of the box?
Well, first, at some level, I sense they have to do it. They have to, in some instances, show their anger and prove that they can't get a better deal and all of that. And you go through it for hours and you're right, we cushion it. To the extent I can get them to talk about the facts and the law and the case, that's helpful. As time goes on and they get frustrated with positional bargaining, they sometimes are more willing now to talk about imaginative things because they can see the pure money exchange isn't working. If you try it at the beginning, they'll view me as a starry-eyed professor. But if I let them for a few hours go through the tough stuff, then we can talk about other things. There are various techniques. I think I filmed Jody, for example, late in a mediation, saying to people, there's going to be blind bidding. You each get to put in a bid. If you're within 50,000 US dollars, we continue. If you're not, we go home. Well, if that's done at 4 or 5 p.m., that sends a pretty clear signal to the lawyers that it's time to get serious. I think if you did it, I don't know if Jody does it at 10 a.m. I think before lunch, it probably would not work. There's bracketed bargaining. I do something called confidential listener, which I think I've talked about in other contexts, which I find very helpful for trying to understand where they really are as opposed to where they say they are. But we have and sometimes they say, time for your bag of tricks or time to pull out your magic. And I think, what is my magic? But that's a different discussion. It's a reality, and it's partly why they need us, partly how they use us.
Yes, certainly.
Go ahead.
Let you finish first. So, Professor, one of the reasons that I find for people getting trapped in an impasse is that they have unexpressed emotional concerns. It may be because there's a block in relationship between business partners, or it may be something said or done in the correspondence that left a scar, so to speak, on the recipient's mind. So perhaps in the next segment, I would like to talk a little bit more about dealing with emotions, if I may, and also how to overcome blocks in empathy. If I can start by sharing my screen, I will tell you you guys a story, okay? And it's based on the real story, and it goes like this. So do you see my screen? Yeah. Okay. So this is not a mediation story, but a kind of street experiment that was performed a few years ago. So it's springtime in New York City, and a beggar, a blind poor man who was sitting on the roadside with a sign next to him and his can, begging for donations. And the sign says, "I'm blind, please help." So every day he does this, and people walk past him, and he receives next to nothing for many, many days, okay? So one day, a very kind lady walks past this poor beggar, and she takes away the sign and swaps it with a new sign. And immediately, people start to react very differently by putting in a lot of spare change in his small can. Okay, so what does the lady do, and why does it have the effect of changing people's behavior so dramatically? Okay, so the new sign says, "It's spring, but I can't see it." So this story tells me something very important, that there are certain messages and certain things that we can say, or certain things that we can do to trigger the empathic reaction on the part of the recipient. And as a mediator, perhaps it's one of the roles and one of the very important things that he or she can do to encourage active listening and parties to express their own emotions in a way that do not offend the other side. Are there any ways that a mediation advocate, do you think, can assist in that process, Dwight?
Well, I think the first thing, and I do think that advocates have difficulty with it because they're in the role of loyal warrior. So they really have difficulty giving bad news, which provokes feelings, of course, of loss, dealing with the other kind of emotions, the empathy that you talk about. So I see them, and I think it's one of the most useful things I can do is to listen to the client's anger or loss, empathize with them. You could say I'm a therapist, but of course I'm not a therapist. But then again, my role is much looser, if you will, or more plastic, if you will, than an advocate's. I can be an advocate for compromise, of course. Sometimes I can set up situations. You can see there's anger in the case that we're seeing on the video, and sort of hurt pride and loss of face. If a lawyer tells me it's happening and helps me think about it, now I can actually do something useful with it, because I really do have freedom that they don't have. I've gone to the houses of CEOs and had breakfast with them and listened to tell me their stories of their achievements, which made them feel better so that then they could compromise, and their lawyer did it. He was very happy for me to do it because he didn't want to have to do it. I've listened, and I'm sure you have, to people who have lost their jobs or been terminated from employment or been injured. I can't say it's anything I learned in law school, and I'm sure I don't really have the temperament for it, but I'm the only one in the room who can do it. And I can do it in a way that the lawyers never could. So I think it's something very valuable that we can do in the right situation, in the right way. I'll maybe turn it over to others to talk about what they've seen happen.
Yes. do you have a video you wanted to show us on this topic?
You know, in this one, I had it from other cases, but in this one, they pretty well kept their emotions, they kept them under wraps, I would say. And so you don't see a great deal. I often, there's an American expression, to show up with your game face on, the face you wear for the contest. And I see business clients showing up all the time with game faces on, and they're like volcanoes. You know there's something boiling underneath, but it usually doesn't explode. And the question is how to get it out. That's where I don't try to do it in joint session anymore. That's where the caucus is so useful as a way of being able to connect. It's also why in emotional cases, I will try to meet with the parties ahead of time. It's expensive, but actually COVID, that's one thing COVID has made easier. You can do it by Zoom. It's not as good, but it's a lot more convenient and inexpensive. And I always ask permission from the other side. Is the defense okay with me meeting with the plaintiff personally? And their attitude is always, better you than us. Better you do it than we have to sit there in a room while you do it in the other room. So I've never had any trouble getting permission. And smart lawyers know that I can help them with their clients. I think it's one of the most useful things they use mediators for.
Okay. Thank you for that. Michelle, I remember you telling us a story not so long ago about a non-commercial case in which you encouraged the disputants to pour out the feelings, and the case, and that had a positive effect on the outcome.
Yes, it was a tragic story. We got a few minutes to tell you the background. A young 18-year-old girl had a boyfriend, and she became pregnant and gave birth to a deformed son who had Down syndrome because she had been beaten up by her boyfriend during the pregnancy. And the boyfriend was then imprisoned, and the girl couldn't cope, and so the child was taken into care. And after 2 years in care, the child was given to a foster mother. And this foster mother lavished all the love and affection of a real mother on this boy for 20 years. But she was always vulnerable because all the money that the boy had got from the Criminal Injuries Compensation Board was, of course, administered by a trustee. And the house she lived in had been provided for the boy. It had been designed specially to accommodate the fact that he was doubly incontinent, could hardly speak, but she was the only one who could understand what he was trying to say. And so the trustee said, look, I think we better have a statutory will to protect you. But 2 weeks before the application to court was due to be heard, the boy caught an infection and died. And as he died intestate under English law, the money in the fund went to the natural parents. Well, the father was disqualified by the court, but the mother, who by now was married with other children, insisted on having the money. And it was a lot of money. It was several millions of pounds. The solicitor for the foster mother wrote to the other side and said, look, we have a claim, and there's a particular provision under the Inheritance Act where you can make a claim if you're a dependent. And the solicitor acting for the natural mother, hardball, wrote the following letter. Dear blank, received your letter. This is the law. And then he wrote these words: your woman has no merit. Now, that was the most stupid thing I think I've seen in the letter, and certainly when they sent it to me. And then when he repeated it in the mediation position paper, I picked up the phone to speak to him. And I said, look, you said she got no merit. That's right. And he started to talk about the law. I said, well, I know all the law. I've done enough cases about it. But you say no merit? Well, if you say so, yes, no, she got no merit. And this was his attitude in the mediation. Now, I had seen both mothers, the natural mother and the foster mother, separately, of course, the same way as Dwight does. And the natural mother told me her tale, which the foster mother had never heard. And the foster mother told me her tale, which the natural mother had never heard. And because the lawyers were completely blocked, and the attitude was, you've got no case. And in spite of my pointing out, the judge will find a way of giving some money to the foster mother, obviously. I decided to take a gamble. So I said I wanted a meeting with just the two mothers and without their lawyers. And they both agreed, and the lawyers agreed. And the atmosphere, of course, was very difficult because the natural mother hadn't seen her son all through his life, had never cared for him. And so there was animosity on the side of the foster mother, and there was a suspicion and an anger on the side of the natural mother that her mother, as she saw it, was being taken. But they began to tell each other their respective tales. And it was remarkable to see that the natural mother's tale had an effect upon the foster mother, and the foster mother's account of her care of this boy had an effect on the natural mother. And so I said at the end of the day, look, the judge is going to ask himself, what's the fair result? If you want to resolve this dispute, I'm going to ask you to go away, think about it, and come back and tell me privately what you think a fair result would be. And they went away for half an hour, and they both came back, and they each handed me a piece of paper with the same figure on it. That the emotion that they both understood each other's tale had brought them out of their respective positions, and they thought objectively what would be a fair result, and they both had exactly the same. They split the money 50-50.
I think we can all, commercial mediators can learn a lesson or two from that tragic story. Perhaps I can move to other examples of good or bad advocacy in the experience of my co-speakers. So we've done so far gone through some examples of manipulative advocates in a good or bad way. Jody, you have some experience you want to share with us, either good or bad?
I think I'm a bit unlucky and I got some bad examples. All right, so this is another one. This time is a property dispute between a plaintiff company and the defendant. The defendant was an individual. So the defendant came to Hong Kong, took up the position of a CEO in a Hong Kong company. So the plaintiff company and the defendant's employer, they were associated companies in a group. So the defendant was like arranged to stay in a property owned by the plaintiff's company. So the plaintiff company said that the arrangement was a bare license, so there was no tenancy agreement, no rent was paid. Unfortunately, the defendant was terminated, I think after he worked for around 10 months. So the plaintiff demanded the defendant to move out, but the defendant refused. He refused to return the keys. So he stayed there for some more time, but he refused to return the keys to the plaintiff. So the plaintiff sued for possession. So the defendant, in his defense, he said that he was promised by the chairman of the group that he would get interest in the property proportionate to his years of service. So the defendant said that, well, he should have some share in the interest of the property, and that worth around 10 million Hong Kong dollars. Of course, the plaintiff said that they were not aware of that agreement. So they came to mediation. The parties talk about different things. And of course, to the plaintiff, the most important thing was to get possession of the property. And somehow the plaintiff raised that they have not seen the property for quite some time. They were not sure whether it has fallen into disrepair. So this is something that they said. And the defendant said, well, we came here to settle. So the defendant asked for a small amount of money to indicate that, well, they are so sincere. So the parties then talk about joint inspection of the property to find out whether it's in serious disrepair or not. At the beginning, they did not mention about costs for the inspection. Then the defendant's advocate asked for the cost of inspection from the plaintiff. they said that, well, my client has conceded a lot. He began with 10 million in the proceedings. Now he's only asking for a few hundred K. So he asked the plaintiff to pay the defendant's cost for the inspection. I think there's just something like 50K. So the plaintiff representatives, they were very emotional, and then they could not accept that. They had to pay a sum of money to inspect their own property. So in fact, I found out that the condition for asking the plaintiff to pay some cost of inspection did not come from the defendant. It comes from the defendant's counsel. So I think this is something that I don't know why he did that, but I think he's trying to put an extra barrier to the inspection. And I think he's trying to show his client that he did fight something for him, okay? So is that good strategy? Did that help to achieve settlement as he claimed in the opening of the mediation? I will leave it to you all to decide, but finally the inspection was done, and it was done without any extra cost to anyone.
I see.
So you can guess who did that.
Let me take a guess. You did?
Yeah, so mediator becomes the someone who inspected the property afterwards.
Yeah.
That's interesting.
Bravo.
That's to break the impasse of the negotiation.
That's a very interesting thing. And on the part of Dwight or Michelle, do you have any other stories that you're dying to share with us?
Well, I can. Jodie's story reminds me. I remember one on a boundary dispute between two neighbours. I resolved it in the end by going out at midnight with a torch and a spray gun and marking the new boundary between the two properties, which both sides then accepted was the resolution of the dispute. That was after a lot of toing and froing, as you can imagine. But I think sometimes we have to step in, and if people are at an impasse, but they do want to settle, then I say to them, tell me privately what your real drop-dead position is, and if you're anywhere near each other, we'll settle, and if it's not, I'll tell you, you all go home. And I've never yet failed to get a figure for both sides. And sometimes they are millions apart and never going to resolve it. Most of the time, they come near enough to each other to be able to resolve the dispute. It's a role that we can fulfill when negotiators are still stuck in their trench and don't want to show their hand and put their head above the parapet. That's when the mediator effectively goes into each trench, gets the figure, and he stands in the middle and helps them to a settlement.
Okay, I have a story of my own to share with you guys. Now, this is mediation that I conducted in my early days as a mediator, and it's a story that's very common in Hong Kong. And you know, there is a whole street in Kowloon called Sneaker Street, where all they sell is sneakers and what we call trainers. And there are many of these shops all crowded on the same street in Mong Kok. So this story was about a trademark infringement case. It's not about Nike. I mean, just use that for as a demonstration. One of the top brands of sports shoes sued this little guy you see sitting in a corner of a very packed little shop on Sneaker Street for selling a pair of counterfeit shoes that had counterfeit trademarks on them. Now, before they went to court, they came to me for mediation because I do a bit of work in my other job as an IP lawyer. Like a lot of IP cases, it was really open and shut. I saw no defense. But in the mediation, this little guy, the shopkeeper, he was unrepresented. And on the other side, the sports brand was represented by an international law firm with a team of IP experts. And so this little guy sitting on the other side of the table, with no lawyers. I recall my training, which was still fresh on my mind back then, was that as a mediator, I must not evaluate the case. I must not offer my opinion, and I must not help either party. But the imbalance was so great that I found it very difficult to resist the temptation to tell this guy, come on, think about it. Look at the offer on the table. The other side has offered to drop all the monetary demands. All they ask of you is to pull that pair of shoes off your shelves and submit to an injunction. They don't want any costs. They don't want any damages. So are you going to take it or not? So I spent 2 or 3 hours trying to beat him into submission without offering an opinion. This guy said, no, I won't take it. It's a matter of principle. I will have my day in court. And I said to him, what's your principle? He said, well, look at my shop. It's full of shoes hanging at every corner, even from the ceiling. How can I tell whether one pair of shoes are counterfeit or not? I just get them from my supplier in China, right? No questions asked. And I said to him, I was at my wit's end, okay? And then I said to him, before you walk out of this mediation, can I give you one last suggestion? Can you, because I found out by then that he's a one-man shop, and he's his whole family was relying on his income from that shop for the living. I said to him, look, have you spoken to your wife about this? And so before you go, could you please maybe give your wife a call and let her know the offer on the table? And so he did that. 5 minutes later, I talked to him again and said, I'll take it. So this is a story where I, as a mediator, found one of the parties a surrogate advocate, and relied on her common sense to advise her client, and brought sense to him. So back to you, Dwight. So you want to move on perhaps to the issue of evaluation?
Before I do, though, I want to say that this has happened to me as well, but often it's a lawyer, including the lawyer on the other side of the case, who knows that there is someone away from the table who will have an influence on the decision maker. And if they tell me this, I can go off and find that other person. But I depend on them because, of course, they've lived with the case and I haven't. So my suggestion to lawyers is you will often know this. And I'm just thinking, in August, I had a mediation between a stepmother and stepdaughters who hated each other, fighting over the deceased husband, father's estate. And they just hated each other, and nothing could be done until finally the lawyer said, you know, she hates my clients, but she really likes the grandchildren. Maybe you could do something with the grandchildren. And sure enough, 60% of the money gets put into educational trusts for the 3 grandchildren, 40% goes to the evil stepdaughters, and we get the deal done, but only because the lawyer told me that there was this possibility. I never could have understood it, looking at people over Zoom. Anyway, on with the next topic, which is the difficult and freighted topic of evaluation. And I have to remind you, was it only this morning? Though for you, it would be last night. No, I'm trying to remember. For you, it was last night that you had the European mediators. When asked about evaluative or facilitative, they all said what I would say, which is, I like being a facilitative mediator. I start facilitatively all the time. At some point, I may have to do something evaluative. The interesting thing is I've filmed now 100 hours at least of a dozen leading mediators from 4 or 5 continents. I've never filmed a single mediator ever saying, you will win, you will lose, your case is worth 500,000 euros or not. They never are that specific. They always are giving little hints and suggestions. So that's a whole topic in itself. But if I were a lawyer, I'd ask, what's blocking this negotiation? Is the obstacle a legal issue? If it is, then evaluation might do something. If it's something else, like the emotions, the bargaining tactics, everything else we've talked about, then using evaluation would be like giving, a COVID patient an antibiotic. It would be excellent medicine, wrong disease. But if it is a legal issue, I would look for a mediator who is willing to evaluate, but only when it's really necessary and to the minimum extent required. I think of the evaluation as something like getting a bus that's stuck in a ditch out of the ditch. My evaluation is the tow truck, but I don't try to tow the bus to its destination. Once I have it back on the road, let it continue. But let me show you what happened in our mediation. This is, again, the mediator talking with the defense. Whoops, have I done this?
Right.
Nope, I've got to stop. I've got to do a new share. I always forget this, excuse me. There we go. I think that'll be all right.
Yep.
Let me come back to my question of whether there's anything important about this to Green Consulting that I should understand at this.
So he continually asks, what's important to you? Tell me what's important, asking for interests. And of course, the lawyer preempts him.
Point
Yes.
before we go any further.
Yes, this is a nuisance case, as far as we're concerned.
Well, I understand that you think it's a nuisance.
No, but it is a case with no likelihood of success. And secondly, we have a deadlock claim on our counterclaim because they have been selling and basically stealing all the money from the sales of our software
So-
without our permission.
How do you get to stealing when there's an existing contract? You said
That
you
was a
didn't-
contract with Monitor. It isn't our contract. We're not Monitor.
But the old deal's still in place, right? I mean, unless I've misread what you both have sent me, that contract is good until, I mean, you have to give them notice until.
It's a contract with Monitor. It's not a contract.
All right, I'm going to stop this. He could be wearing a mask. This was filmed before COVID, but he could be wearing a mask. And if you only saw his eyebrows and his eyes, you would know what his opinion is of the lawyer's argument. And so does the executive. He's giving an evaluation without ever using words. He's using a Diet Coke can in his eyebrows, and that's enough.
With Greek.
I mean, you can't have it both ways, right? If you're due some money, they must be eligible to sell it.
We bought Monitor's, certain of Monitor's assets, including the software.
And, right?
And they are selling assets that we bought.
The issue also is we have no idea what they have sold.
Okay.
And one of our concerns is the amount and having that verified.
So presumably that could be verified.
Well, it would be helpful to us in resolving this case. Can I make a suggestion?
Yeah.
Why don't you get the amount of sales they have made? We have the amount of sales we made. We'll exchange those numbers. While you're arranging that, we'll consult. And when you come back and we exchange the numbers, assuming the numbers are not wild, we would then review what our response to the 2 million would be.
All right. Perfectly happy to work that way.
So there you are. They have a little, I call it, evaluative interlude, never mentioning words exactly and only in terms of questions, but there it is. And I think the lawyer knew perfectly well what the mediator was going to react and wanted his client to hear it as a way of, softening up the client for advice the lawyer would give the client later. As soon as they finished that, as soon as the mediator hears a suggestion, maybe there's an information question that information could be exchanged, he immediately turns there and now we're facilitative again, without any opinions. I see lawyers moving back and forth. If you have a couple of minutes, I can show you Jody delivering an opinion with just her eyebrows. And I see Lim Tot, the head of the Singapore Mediation Council, is listening in. I've got a little video of Lim Tot looking with just a sigh, nothing more. And it's quite clear what the opinion is. I see mediators doing this, very good mediators doing this all the time. And I see lawyers expecting them to do it and valuing if they do it in the right way, at the right time, and nothing more. And then go back to facilitation, which is really what lawyers want also. So I guess that's, if you'd like to see a couple of minutes of the video, I can show you them doing it, but otherwise the others may have comments about the use of evaluative gestures, expressions, tone of voice, and actual opinions. I'll just finally say, when I film these mediators evaluating, it's always verbal. It's always, I have some concerns. I am a little concerned that there may be a problem. Never do I see them give a number, a percentage. I will do that, but it's very hard to see mediators doing it, even ones that are thought to be evaluative. So with that, I turn it over to my colleagues who have seen at least much or more of this than I have.
Well, as I said, in Hong Kong at least, we're very, put it this way, conservative in the sense that most of us have been trained and brought up in the facilitative model.
Yeah.
We've been told that if we venture an opinion in any shape or form, we risk losing our impartiality, and we will lose the trust of at least one of the parties. And once we lose that trust, we can't help get it back again. Is that your experience in the UK too, Michelle?
Possibly, CW. I think the thing is that most lawyers choose a mediator who will do the business, i.e. get them to a settlement. And people say to me, are you evaluative, facilitative, transformative? My stock answer is I am whatever it needs at any particular time of a mediation for the particular needs of the parties at that stage. So I'll start off being facilitative, there'll come a time when I'll be transformative, there'll be a time when I'm evaluative. But it's not a deliberate policy, it evolves as one's going through. But the tricky question is when somebody says, what do you think, Michelle? And what I normally say to that is, what I think doesn't really matter, because I'm not trying the case. But what I do try and do is get the parties to identify, as the professor has already said, exactly what it is that's causing them not to settle. And I have some stock positions. If there's an argument between witnesses as to who said what or who did what, the one warning that I give parties from my experience sitting as a judge is that I defy any lawyer who, with any sense, to guess with any certainty what any judge will make of any witness, because we've all got that horribly wrong. Cases we thought our witnesses were so good we couldn't possibly lose, come lunchtime, we're out getting drunk because it's all gone pear-shaped, and vice versa. Cases we were dreading, the witnesses suddenly appeal to the judge and we're out buying champagne. And so if your case turns on your belief that your witnesses will be accepted, beware, because you can't guarantee that. And if it's an issue of law, then you identify the issue of law so that the commercial boys can then put a price tag on what they value that particular point to be. And so that's a way of not being evaluative, but forcing the parties to face the reality of what it is that's separating from the settlement and being able to run their own risk-reward analysis on the value of that particular point.
CW, on the issue of whether you would lose your impartiality, I'd remind you that every lawyer gives clients advice that their case is not as strong as they would wish it to be and manages to keep the confidence of the client. The client If you can't tell a client there's a problem without the client thinking you've been seduced by their opponent, you can't be a lawyer. I can do the same thing, but I can't do it at 9:30 in the morning. I have to form a relationship with them. They have to know I've listened to them. They have to know I've carried their arguments to the other side. Before I give an evaluation, I articulate their case back to them so they know I've heard it and I can argue it. And yet, I say we have to play a good coach. Doesn't just talk about what his team will do. He talks about what the other team will do and thinks about what the response is. And that's what we have to do. Anyway, that's my thing.
Absolutely right.
Before I go to Jody, maybe for a final comment, I'm looking at questions from the audience. We have about 4 or 5 minutes left in our session. I welcome anybody from the participants, and I counted at the peak 109 of them. Some of them from our across the border in mainland China, and a lot of familiar names I can see, but not the faces. You're very welcome to drop any questions or comments that you may have in the chat box. But before I see any of them, Jody, do you have any further comments on how evaluation can be used, or should we use it at all?
I will not say that I do evaluation, but as Joyce mentioned, when he taped me in mediating, I will do that in a very subtle way. So when people say that, oh, they are very confident with their case and they have very good chances of succeeding in court, I think I would make use of the material that I've heard from the joint session, that counsels from the other parties said something about the merits, and then I would just begin from there. And sometimes before the mediation began, I will also ask the both parties to give me well, if there's some cases or authorities that they think are relevant and they think that it will help me to understand their case better, I will ask them to give it to me so that I will be better prepared. And then I think it depends very much on a case-by-case basis whether counsel are prepared to do the discussion. Sometimes the counsel are very well prepared to discuss the legal issues, so they will, I will arrange a lawyers caucus, so they talk about it amongst themselves. And at the end of it, I will summarize, and they will try, and they will kind of see what's the key differences, where they stand and what the risks are. And then I will ask them to go back to their room and try to come back and with another offer or whatever. So this is something that I will usually do. And for those cases that it depends very much, like what Michelle said, the you said, I said thing. So I always like talk to the parties and also to their lawyers. What's your experience of saying something in court, being a witness? How could you be sure the judge will believe 100% of your story? So this helps to soften them a bit. And sometimes I will go to parts of their evidence, which when I read, I have questions. And so the lawyers will later on say to me privately and said, Julie, it's good that you bring that up. And then we will talk about that more in the caucus with the client. Yeah. So this is something that I will do.
I see. We have 1 more minute left in Zoom. I don't mind overrunning a bit, but let's deal with this question first. Now, this relates to co-mediation, and I myself haven't done one before, but I understand that this is where 2 mediators sit together, sometimes with each party nominating one mediator, and the dynamics can be quite interesting, and certainly there will be some scope for manipulation. I can talk to my mediator, you talk to your mediator, and see how it plays out. So the question from Teruo Kato is whether any of you have any experience, good or bad, with co-mediations to share with us.
I've done very few of them, but they've worked well. typically what happens is one side wants me for their process expertise, but they think that they need, excuse me, an expert on IP or an expert on antitrust law or some specialty. So they get someone who has got a little training as a mediator, but is a recognized authority. As long as we agree to split things up, actually, the IP expert can be very, very evaluative, and I can be Mr. Facilitation and spreading calm on the waters. That works very well. Rarely do people want to pay for two mediators, which is a little strange considering the amount at issue. It seems actually a fairly small expense compared to all the lawyers I see in the room. But anyway, I don't know if Michelle or Jody have reactions.
Yes, I've co-mediated as well, and for the same reason that Dwight, that they want somebody with expertise in a particular area of law or practice, and they want a mediator to be a mediator. But the one golden rule that I caution everybody is absolutely make sure that your co-mediator and you liaise throughout the whole day, so you're not stepping on each other's toes or going into a room on your own and saying something to the opposite of what your co-mediator has said to them already. So always share notes and agree beforehand what the particular roles will be for each of you.
I'll just say the other area where I've had co-mediators, construction cases. You have 20 parties. You could spend the entire day going around just talking to each of them for 20 minutes. So now if you have two mediators, you can split up, but then you do have to check back constantly.
Yeah,
that's true.
Okay. As if there's multi-party, it's very helpful to have. So somebody isn't sitting for 3 hours on their own. You can each box and cocks with different rooms. Yeah.
Okay. Jody, any comments on that?
I co-mediated, but not a lot. I would not co-mediate with people whom I don't know. So it must be someone that I know well enough so that I know what he or she will be doing. And I think the last time that I co-mediated was a case that one side, they were with a team of lawyers, which was some of my ex-colleagues were there. So they know that the lawyer was kind of difficult. And so the mediator who initially mediated that case, he invited me to join in the team so that I could talk to that party's lawyer. So sometimes it's because of people, the dynamics that may help.
Okay. Thank you, my co-speakers. Dwight, Michelle, and Jody for joining us this morning. And I know it's getting to 3 a.m. in London and Boston. And so
don't look that tired, TCW.
coming in at odd hours. And on behalf of the Hong Kong Mediation Council and the IAM, I thank you and all the participants for joining us. Please stay tuned for our Capsule 6, which will start in how many hours, Jody?
I think in the next 24 hours, yeah, it will be tomorrow, 9 a.m. Yes. So that will be our last capsule. So we have a lot of speakers from IAM. A number of them are past presidents of International Academy of Mediators. So they're going to share with us their experience and insights about the future of mediation.
Okay, thank you all, and look forward to seeing you in about 22 hours. Thank you.
Thank you.
Great pleasure. Thank you, Dwight. Thank you, Jody.
Thank you, Michelle. Thank you, Dwight.
Good night. So